Ready, start. These two appeals impugn a common judgment and order of the High Court of Delhi at New Delhi dated 15/11/2018, inter alia, passed in criminal appeal numbers 1015 of 2017 and 1132 of 2017, whereby the appeals of the appellants preferred against the judgment and order of the trial court dated 16/8/2017, passed in sessions case number 78 of 2014, were dismissed. Full stop. The appellants, along with two others, were tried for offences punishable under sections 392, 397, 411 of the Indian Penal Code, 1860, and section 25 of the Arms Act, 1959, in connection with FIR number 512 of 2011 at PS Nand Nagari, Delhi. Full stop. Appellant Wahid was convicted by the trial court for offence punishable under section 392 read with section 397 IPC, but acquitted under section 411 IPC. Full stop. For his conviction under section 392 read with section 397 IPC, Wahid was sentenced to undergo rigorous imprisonment of 7 years with fine of rupees 5,000, coupled with a default sentence of 2 years. Full stop. Insofar as appellant Ansu is concerned, he was convicted and sentenced under section 392 read with section 397 IPC to 7 years of rigorous imprisonment along with fine of rupees 5,000, coupled with a default sentence of 2 years, semicolon. Besides that, he was also convicted for offence punishable under section 25 within bracket 1 of the Arms Act and sentenced thereunder to 3 years rigorous imprisonment along with fine of rupees 2,000, coupled with a default sentence of 6 months. Full stop. There were two other accused, namely, Narendra and Arif, who were also tried and convicted, but since they are not before us, and it is reported that they have already served the sentence awarded to them, we do not propose to deal with the merits of their conviction, though they had also separately preferred appeal before the High Court. Full stop. The appellants, Wahid and Ansu, had separately preferred appeal against their conviction before the High Court. Full stop. Aggrieved by the dismissal of their appeals, the appellants have preferred these appeals. Full stop. Before we proceed to notice the submissions made before us, it would be apposite to notice in brief the prosecution case. Full stop. The prosecution case, bereft of unnecessary details, is that while complainant within bracket PW 1 bracket close was traveling along with four other passengers, driver and conductor in Gramin Seva at about 11:25 p.m., in the night of 3/12/2011, four persons boarded the vehicle near Gagan Cinema. Full stop. Those four thereafter threatened the passengers with knives, screwdriver and country-made pistol, robbed them of their mobiles and cash and deboarded the vehicle. Full stop. The driver thereafter took the passengers slash victims to nearby police. Full stop. The police officer present there was apprised of the incident and later a formal first information report was registered at police station, Nand Nagari, Delhi as FIR number 512/2011. Full stop. The investigation of the case was carried out by PW13, who, allegedly, on the basis of information provided by the complainant, effected the arrest of all four accused on 5/12/2011 from near DTC bus depot at Nand Nagari. Full stop. According to the prosecution, at the time of arrest, Narendra alias Bola had a knife, Ansu had a country-made pistol, Arif had a button-operated knife and Wahid had a screwdriver. Full stop. Besides that, they had some cash. Full stop. On 6/12/2011, according to the prosecution, looted mobiles were recovered separately at the instance of accused Narendra and Arif. Full stop. We have heard the learned counsel for the parties and have perused the materials on record. Full stop. The learned counsel for the appellants submitted that the FIR named none of the accused persons, The incident occurred in the darkness of night, semicolon, and the accused and the witnesses were not known to each other, full stop.